Before we move on to the next topic of damages, a quick word about the procedure once an ex parte injunction is granted. Now, an interim injunction can be granted even without hearing the other party, and that is called an ex parte injunction. Now, even among injunctions and ex parte injunctions, there is something called a key timet injunction. It's spelled as QUIA space TIMET. A key timet injunction is where no real damage has occurred yet, but there is an apprehension of damage or injury. The hypothetical mentioned through this lecture is an example of a key timet injunction being sought. Now, in some cases, the party may be of the fear that if the other side, that is the defendant, is aware of the litigation against him, he is going to release the film in advance and thereby ensure that an injunction does not fall to be of any great effect. In order to get over this, it is open to the plaintiff to move the court without notice to the defendant. And the court can indeed grant an injunction without hearing the defendant. But in a situation like this, it is imperative on the part of the plaintiff to intimate the defendant of the order of injunction within a period of 24 hours from the date of grant. And the defendant then has the right to move the court to vacate the ex parte injunction. So ex parte injunctions are granted on standards pretty much similar to the grant of a normal interim injunction where both parties are heard, but with the additional caveat that the plaintiff has to intimate the defendant of the order in question within a period of 24 hours along with a copy of the typeset of papers in the case. Now we can proceed to a consideration of the other remedies that are sought in the case of intellectual property rights infringement. The most important of these is, of course, damages. Damages are a situation where one suffers loss and the loss can be compensated in money terms and a certain sum is fixed. Now, how does one compute damages? Again, a pretty complex question, and in this lecture we are not going to look so much into the nuances, but broadly there are three kinds of damages that we must bear in mind. The one most common is normal damages, where the attempt of the court is only to put the parties back into the position in which they would have been had the infringement not occurred in the first place. So here again, the court can either compute the loss suffered by the plaintiff and ask the defendant to pay that loss, or it can even look into the profit gained by the defendant as a result of the infringement and direct the defendant to keep an account of its profits and in the ultimate analysis compute the same, and based on the choice exercised by the plaintiff, either grant compensation for the losses suffered by the plaintiff or direct passing over of a percentage of the profits earned by the defendant. So the latter kind of relief is basically called rendition of accounts. So in many cases the court, even at the interim stage, and largely in cases where it is not fully convinced that granting an injunction would be fair to the defendant, as in it has its doubts as to whether such grant of an injunction would be fair at all. In such cases the court can, and the court does, still give some relief to the plaintiff by way of directing the defendant to maintain accounts. And in ultimate analysis, once the trial is over, if the court were to come to the conclusion that the plaintiff is indeed entitled to damages as a relief, the court can ask the defendant to furnish the accounts that it has maintained thus far, and then either compensate for the loss suffered by the plaintiff or ask the defendant to pay some part of its profits to the plaintiff. So this is how ordinary damages work. But over and above this, we have a category called exemplary damages. The idea behind exemplary damages is simply deterrence. The court is really looking here to deter the party and also other third parties, the infringers who are watching on the sidelines. So the idea is to send out a strong message. If you are the kind of defendant who, eyes open, decides to violate the intellectual property rights of a plaintiff, we are going to come down heavily. We are going to impose the kind of damages that is not really serving the purpose of compensating the plaintiff as much as deterring everyone from playing fast and loose with the law. This sort of exemplary damage payment or order is not uncommon in the Indian legal system, especially post the early 2000s. Courts in India are very receptive in cases of willful infringement of intellectual property rights, especially in software piracy cases or in trademark counterfeit good cases, to impose such hefty damages. So exemplary damages today are, though not the norm, certainly a practice witnessed on the ground. As to the deterrence effect of these orders, I personally feel that in computer software piracy cases, many commercial organizations today, much more than the personal use licenses, many commercial organizations are quite apprehensive about using pirated software, because if there is any sort of discovery of that, one, they could pay exemplary damages, and two, and this is what we are going to discuss at the very end, and that is the next, we are just moving into that now, the court can grant an Anton Piller order, and this is a very serious order, especially when it comes to commercial organizations. So what really is an Anton Piller order? It is not an order meant to deter parties, unlike an exemplary damages order, but it does have a significant deterrence effect today, the way it is being operationalized. So in an Anton Piller order, again it's a matter of interim relief, wherein the court appoints an advocate commissioner to go and search the premises of the defendant, to seize infringing material if any, and to report back. So it serves a very important purpose of preserving the evidence of infringement. Because in many cases what happens is that once a suit is filed and an injunction obtained, the defendant can very well destroy the infringing material and then say that he never committed infringement. And this is particularly the case with computer software. You can easily delete the software from your system. You can uninstall it. So how is it that the court can ensure that what the plaintiff says is absolutely true and that the evidence is preserved? It is with this narrow objective in mind that the Anton Piller order was fashioned in the first place. But today, the way the order is being operationalized, it can also at some level amount to a threat. Why is this so? Because the Advocate Commissioner is granted the power to search the premises and not only gather the evidence and prepare a report, but also seize hard disks and other material which can prove the evidence of infringement later. As a result, the entire business of the infringer or alleged infringer can be put to a standstill, and there is therefore the large apprehension and threat that one will have to suffer extreme consequences for use of pirated material. Due to the grant of these Anton Piller orders, therefore, I personally feel that there is increased apprehension of being caught on the part of commercial entities especially, and if being caught, being put to the kind of hardship that an Anton Piller order does put you to, so parties are a lot more careful. So this is where we stand today when it comes to the various remedies in civil law, that is in civil proceedings, for enforcement of IPRs. Before concluding, I would just like to add that finally, as much as we can confer substantive rights of different kinds, the real protection of intellectual property, its efficacy, even its fulfillment of its underlying objectives such as the incentives function and the production function, all of it depends on how effective the remedies of enforcement are. Thank you.